had just completed his work killing the law of the sea treaty in the United States Senate. And that was in 2007. We remained in contact and friends ever since. And Larry brought forward a lawsuit that was based on the Federal Data Quality Act. And so as we discussed that, and as Larry discussed that with attorney generals all over the United States, we saw that the water scandal here in the state of Montana, it was applicable. And so from Christmas time till April, we saw how applicable his litigation was to the water scandal here in the state of Montana. The title of water, which is private property of the people of the state of Montana, is being transferred to the federal government via Indians, and that's a regulatory taking. Now, if the federal government takes, they owe compensation. The problem with a regulatory taking is that you have to prove harm to the feds who took it after the fact. You have to be driven to your knees begging for mercy and going hat in hand to the federal government for relief. What we're hoping to do is kill this compact in the United States Congress and make sure that there is a compensation mechanism in place for you folks should this insidious, unconstitutional transaction take place. There was procedural issues that made this entire process stink to high heaven, where there's great suspicion that it was not exactly kosher. We hope to convince Ryan Zinke that, and thank goodness for this man. Thank goodness for the research that he's done. We have not only unearthed the fact that your private property is being stolen with the help of your legislature. The entire government of the state of Montana has dirty hands, in my humble opinion. But we've also unearthed the fact that there are profound national security implications to this. And we hope that the legislature of the state of Montana reconvenes and cleans up the mess that they made before this thing becomes an unmanageable mess. The judicial branch, the executive branch, and the legislative branch crammed it down your throats, and we're here to fix it. Regulatory relief is in place to raise the substantial amount of money that is necessary to pay Larry and his legal team, not only his legal team here in the state of Montana, but we have the finest lawyers in Washington, D.C. that helped him. In fact, the Solicitor General of the Bush Department of Defense, when Larry submitted his litigation to the gentleman, he said he had no choice but to, because it was so thorough and well researched with the facts, the law, and the evidence, that he had no choice but to introduce Larry into the federal court in Washington, D.C. So those who criticize the efforts that have been taking place here should understand that this litigation was reviewed by the Solicitor General for Bush's Department of Defense. It seemed to be so profoundly important that he marched Larry up and introduced him to the courts. And now we have all sorts of national security implications, and we have no choice but to move forward and try and cancel this fraudulent, crooked contract before it takes down the people of the state of Montana and their private property, their heirs, and the property that they would inherit. And Also, we don't want to see the state of Montana colonized by people that we have, that were not vetted, that are not vetted, coming into our United States and doing things on these reservations that even Stephen King or Tom Clancy couldn't even make up a novel about this. So I see a room full of people my age, and I think what is really important is not only to raise money to fund this litigation, is we have got to get the younger people understanding what the long-term implications are, what they're going to inherit or not inherit, what private property means as a cornerstone of our constitutional rights, our basic civil rights. This is what Magna Carta 800 years ago, the cornerstone of that document was the right to accumulate the fruits of your labor and hold it so the crown couldn't seize it. And we have the right to defend it, whether it's in litigation or otherwise. We have the right, the absolute right to protect our private property. That's why you're here. That's why we've hired Larry, and that's why we beg you to bring your children and your grandchildren into this conversation, because they're the ones that have the most to lose. Thank you very, very much for your time and your attendance. I know a lot of you came from all over the country to hear what is being said today. Please carry the message. Thank you.
I didn't want to get you in trouble with our wicked timekeeper. You very much well introduced Mr. Kogan. So I think rather than any more, I'm just going to have Mr. Kogan come up here. So Larry, Lawrence Kogan, Kogan Law Group from New York, is our next presenter.
Thank you. Thank you. I'm told I have to eat this microphone in order for you to hear me.
You can hold it.
Okay, I'm told that I have to stay within this frame so that they don't have to move the camera, so what I'll do is I'll probably move along the side of this podium and just to test you to see if you're still awake by the time I'm done. Okay, now that photo on that screen is the theme for this morning. We are in an altered state of reality, okay? We are dealing with Alice in Wonderland. With federal Indian policy and environmental policy under this administration, the Barack Obama administration, we jump into a rabbit hole and we come out another end and it looks nothing like the reality in which we were raised. And I thought perhaps, you know, you might get more out of looking at the imagery and then be able to relate the imagery to what I'm going to speak about in general broad strokes this morning. Yes, we have brought a lawsuit in the beginning of September in an effort to push back the conveyance by the federal government of a very large dam with very significant consequences for you all and other people down past the reservation without following the rule of law, without providing any of you your procedural, administrative, and constitutional rights. This administration doesn't believe that you have it. They told me so much in the emergency hearing that we had in Washington, D.C. in the U.S. District Court for the District of Columbia. The Department of Justice lawyer stood up and said, it is up to the discretion of the agency whether or not you have a right to a public hearing. Now, to tell you the truth, I didn't think I was in Washington, D.C. that day. I thought it was in Havana, Cuba. We had a predetermined outcome. We had a judge who was assigned to our case, who was a well-known scholar on federal Indian environmental policy, and he happened not to be available that day. Very convenient that he wasn't available, but he's still assigned to the case, but nevertheless, we had a judge who could be trusted to provide the result the administration wanted. And without making any, casting any aspersions as to the quality of his judgeship, we knew the result was going to be a certain way. In the beginning, he asked us not at all to talk about national security. The country of Turkey and any other Middle Eastern country is totally irrelevant to the focus of the case. That's partially true, partially untrue, but nevertheless, he decided to cherry pick the record. He also said we should be talking about racial discrimination and other such issues because that clouded the focus of the record, which the government wanted to portray narrowly. And the way you frame the debate is usually determines whether you win or lose it. So when the government wants to frame the debate merely as a challenge to a regulatory agency's order, then you have a very narrow frame of reference. You can only take into account so much information, and you have only so many days to bring the challenge. That's the way they wanted us. They wanted the court to view the case. But this case is much broader than that. We went to that district court rather than to the appellate court for the DC Circuit for a reason, because the procedural violations that started back in 1985 and continued on to the present day is a pervasive, systemic, intentional abrogation of your rights in multiple settings, in administrative law, in regulatory law, in constitutional law, and they don't give a damn. Okay? There are tolling statutes or continuing violation statutes in the law and sufficient case law that show that if the government agency continues to deceive the people over a course of years, there is no more a statute of limitations. Okay? The government doesn't like that argument and would rather bring us back into that narrow rabbit hole of contesting a simple order. And since you didn't contest the simple orders beginning in '85, they say you don't have a case. That's their preferred reality. That's their Allison Obamaland black hole, their rabbit hole. The problem is, the reality and the factual record is rich, and we're going to be pulling that record up. There's a lot of law that defends your procedural rights. The government does not want to adhere to it, they don't want it recognized, and they certainly don't want us to talk about national security. Because when you add up the special status of federally recognized tribal entity, it adds up in sum total to federal agencies. We will exempt this tribe from all types of regulatory requirements as to every single agency that has jurisdiction over the tribe on a given regulatory matter. And when those exemptions add up, you get a big hole. You get a hole with respect to dam security. This dam hasn't been inspected since 2012. This state doesn't even entertain, let alone participate, in information exchange with the Department of Homeland Security. So what you have is you have two major dams. This Kerr Dam, and I'm going to refer to it as Kerr Dam because that's its rightful name, and the Hungry Horse Dam above it have no security. We were at the Hungry Horse Dam back in August, and we could just walk anywhere we want. Now, if we didn't have good intentions, I would not want to imagine what might have happened. You're also within 100 miles of the Canadian border. Okay, that's a porous border, as much so, or maybe even. Am I loud enough?
No. Did you turn the switch off?
I didn't touch anything. It's still on. How about now? No. This is the second venue where we had no microphone.
Yeah.
Let me have a backup. Let me set this back up.
These must be made in China batteries.
No doubt.
I'm adding minutes to the time.
Yes.
While we're waiting,
Yes.
might I bring up the fact that Kerr Dam is a black start part of the power grid?
Yes, I think you
That
should.
has not been addressed as far as I know. What I mean by a black start is if we have a total blackout, that is one of the power systems that will regenerate, turning the whole grid back on. So there is a significant security risk associated with Kerr Dam.
Well, beside that, it's deemed a Category 3 hazard, which is the highest hazard. If the dam fails, there's lots of people who won't be here anymore. Okay, so this is a high security dam. The federal government has many dam safety and security reports out there that we included in our legal filings that the federal government would rather not pay attention to because it's not within its narrative. Okay, we're in a world of postmodernism, which means this government as well as the European government and other governments around the world, reject the Enlightenment era. They reject all the principles that this nation was founded upon. Okay, so they just recreate narrative. They deny the existence of prior history, and they make the young people have to search for the facts. And when the young people can't find the facts, they doubt the past. And the only thing they have as a reference point is the present, or what the government and the other false acolytes tell them the future will be. Amen. They've got nothing to compare. And when you create that kind of doubt, you have a big problem, because the young people don't even know what they lost because they never knew they had it in the first place. Okay? There was an article in the Missoulian. I don't even want to raise the fact of its author. I'm out again? Well, let's get back to the Black Star Dam. The whole point is that it's a hydroelectric generating facility, which means that it doesn't need the rest of the grid to turn back on. And then it can support other infrastructure. That's a very important facet of hydroelectric. Putting aside that the Greens like it to some extent because it doesn't create much of a carbon footprint. Okay, now I'm real concerned about that, but really they don't like hydro dams in many cases, especially if they're older, because they swallow up fish. Okay, so they're taking dams down not only out west, they're taking them down in the Midwest. I know because I have clients in the Midwest that deal with dam FERC licenses. So the point is, this is a national phenomenon. It's not limited to the West, but they get to take advantage of you all because you're spread out, because you may not necessarily be hooked into the internet as well as the people out in the Midwest and the East, and they can create a narrative to change reality and bring you into a rabbit hole from which you cannot come out. You know, and the point is, do we have the other Made in USA battery? Yes. Okay. We have a warranty on that. Okay. But the point here is that I come from New York, which is, you know, the People's Republic of New York, and I admit that. Okay, and I can't make more apologies because then I'll sound like Barack Obama making apologies for our country. So I don't want to do that. The point is that a lot of these environmental laws were not made in USA. They were made in the European Union. Okay, the regulatory frameworks that we've been tracking since 2002 came out of Europe. They came through the federal government, especially beginning in 2009. And then they made their way to the states and to the cities and to the towns because of the opening up in the UN of all of this asymmetrical governance. Okay, that means a city from, you know, any state can talk to a national government at the UN and get recognition. Okay, so you have all of these rules now that are being brought in willingly by your representatives at the federal, state, and local levels because they're now citizens of the world. Now, there's nothing wrong with being a citizen of the world. The question is, what world are you a citizen of? Okay, is this a world where they even recognize that we have a unique national constitution, that we had a Declaration of Independence that spoke truly about what this country is all about? We are a historical anomaly to the world. They don't like us. We stick out like a sore thumb. Okay? This federal Indian policy is another symbol of this postmodern era. Okay? Where they take apart the past, they put it together in a new way that's attractive to their agendas, and they tell you that the past that you know never existed. Yeah. And how dare you even try to reference something from the past that you know? Because that past doesn't exist anymore. And that's what we have here. We have a rewrite of history at the federal government level that basically says that the tribes gave us the right to exist on this land at this point. They gave you the right to have water. Okay? And what we're going to do over the course of time is to basically restate the truth through the correct legal narrative and show them up for what they are. Frauds. Total frauds.
Yep.
Okay? It's going to take some time. We are going to have to hammer them. But it's unique in the annals of American history where you have a government that doesn't even respect the founding documents. Right. They don't respect your natural rights. They don't even believe that you gave them the license to govern you. They think like European dynasties think, that they allow you to live or die. This is upside down. This is Alice in Wonderland. Okay, what we're trying to do through the courts, I mean, we could try to do it through journalism, but that's not going to get us very far. Because why? The journalists, mostly, are for the administration. That's a fact. That's not a fiction. They like to tell us that we're paranoid because they want to discredit anybody that disagrees with them.
Right.
You can't raise a challenge to this administration without being a racist. That's sick.
Yep.
Okay, we grew up in an era where everybody was able to say things that we wanted to say and no one was offended. Now we can't even think about something because it might offend somebody. That makes no sense, but it gives them a narrative to use to defend what they're doing. When they make you guilty of exercising your constitutional rights, something is terribly wrong and it's got to be peeled back. Lana Markison and I and my counsels in Washington, Joe Schmitz is, Bob, I just need to correct that, he was the former Inspector General, not the Solicitor General, the Inspector General of the Department of Defense. We're tied into other people in the national intelligence community that know what's going on, and they know that this government, just like with immigration, is not enforcing the rules. This is a cover-up, and we're going to, through time, we are going to expose the facts of a cover-up, a massive cover-up. Okay, they want voters. In this state, unfortunately, you don't have immigrants from Mexico that could be your voters. So you have to go to the tribe. And the tribe is pulling this and benefiting from this to no end. The tribe has no accountability, it has no transparency, it has no obligation. All it wants is to be honored. When George Oshensky wrote in the Missoulian a couple of weeks ago, honor the Salish Kootenai, I said in response, heck, honor the rule of law.
Right.
Yeah.
They don't want to honor the rule of law because they make it up as they go along too. They're in cahoot with the government because, again, when you look at a government's role as a communalistic, communitarian, socialistic endeavor, where the government tells you what you can and cannot do, as they do in the European Union, which is confirmed, because you used to write back to me when I used to criticize them for that. It's in The Economist, and I'm sure, Sam, you could find it, if you want to look, that this is the type of government we have now. You don't own your property, they give you the right to own it. Okay? You don't have the right to free speech, they gave you that right too. You don't have a natural right, it's a government grant. Okay, there's a difference in law between positive rights and negative rights, and they believe you have positive rights. We began this nation with negative rights. We had the right to exclude others from stepping on our property, from stepping on our ability to speak freely, to practice our religion as we wanted. But now, through regulation, they've converted those natural rights into positive rights, which are subject to the discretion of the agencies. Your constitutional right to a public hearing to address your concerns on a given matter have been converted now to a regulatory right to a public hearing based upon things that were not yet entered into the record or new information. That is total crap. Okay, as a lawyer, I just was sworn into the Federal District Court of the District of Columbia. I'm already sworn into the Circuit Court there, the Appellate Court, and the U.S. Supreme Court. Okay, when I had to take the oath to uphold the U.S. Constitution, I was actually laughing to myself, how many other attorneys in this room actually will do that?
Yeah.
I doubt it. They had all these Greek statues sitting on the back wall. It looked like Plato's Republic, and they were swearing allegiance to Plato's Republic. Okay? Sad, but true. This lawsuit is intended, actually our engagement was originally due to Mr. Fanning. Mr. Fanning pleaded with me back, beginning in February of this year, come to Montana, speak up at the judiciary hearing in the House, and tell people really what they need to hear, because the narrative that was given to you all by people both from within the state and carpetbaggers from without the state was narrow. They told you it was all about the hydrology of the water. They didn't tell you about rights and procedures. They didn't tell you about science. They didn't tell you about property, because they didn't want you to think about that. They wanted you to focus on the technical minutia of hydrology. They wanted to focus you on the political good that would be established by giving the tribes the dam and all of the on and off reservation land, environment, wildlife, and water rights that they desired. That was the right thing to do according to the state governor's office, the attorney general, who still hasn't put his opinion online for people to see because I imagine he never did an opinion, or he probably wasn't really very good and he didn't want anyone to criticize it. And I invite Mr. Attorney General Fox to do that. I'd be happy to review it for you, Attorney General. Essentially, I wanted to come in April. People were going to fly me in, and I was told it wasn't necessary. The people in charge had everything under control. Not necessary for you, New York lawyer, to come into Montana. We Montanans got everything. We've got it all buttoned down. That bill will not pass. Lo and behold, a week later, it passed. The question I have is, why do they keep me out of here? What do they not want me to know? And we started to dig. And then we dug some more. Like an onion, you find smelly things that each layer down you go. So yeah, is there corruption out there? No doubt. Is that our primary focus right now? No. We're not out there to take people out. We're out there to restore your rights. We're out there to tell you what your rights truly are rather than what the narrative says they are. Now, Kerr Dam is integrally related to that compact. There are several clauses in that compact that relate both to the low-cost power block that's guaranteed following the passage of the compact, consistent with that 1985 license that the government screwed around with in the 90s. In addition, it talks about reserved water rights. But they don't tell you exactly what the reserved water rights are. They just tell you what they want you to hear they are. And that's what we're here to do, is unravel the strands of knots that they've created so that you can't figure out the truth. I know how this is done because I dealt with the European Union on the same type of modus operandi. They make things so complicated, as they did even in the Soviet Union, that you can't figure it out. What was it that Stalin said? Tell everybody they have rights, but never let them exercise them. That's what we have here. Mr. Obama takes pages out of the Stalin doctrine, okay? He takes it out of the European Union, which is not a capitalist society. Sustainable development is a compromise between Marxism and capitalism, and they won't tell you that. We have the legal research. It's in a law review article I had recently had published. When they say Agenda 21 is for propeller heads, that's because they want to dissuade you from going there. We have the legal basis for all of these rules. We've tracked them from Europe through the UN, back to the US government, into the states and localities. We have the track. They can't dissuade us from our mission to blow this whole false narrative to pieces. And that's what we're going to do in a court of law, but we need your help to do it in the court of public opinion, in the public square. You need to do what you're required to do here, and I'm going to give you homework. It is to re-emphasize what the founding principles of this nation are. It is to talk to the young people and let them know that the narrative that they've been given is untrue, that they have an obligation to themselves, to their families, and yes, to a nation. This is not yet a one world. This still is a nation. We have boundaries, we have borders, we have laws, we have rules, we have principles, and we have a national constitution that is the envy of the world. It is unique in the annals of history, and they don't want to acknowledge that. And we have to get them to wake up, because if they don't know what they've lost before they've lost it, this country's doomed. Okay? This lawsuit is only a small part of that puzzle, but it is going to be a very large effort in reestablishing both the historical and the legal narrative that once was. Okay? That we promise to you, we will make every effort in our power to do that. We will be facing overwhelming odds. The government will try every trick in their magic bag to prevent us from doing that. They will try to disparage everybody that wants to help us achieve that goal. They will turn the heat on. The tribe will send warning shots in the air, or they may come just so that you are intimidated by their presence. But they are unlike any other dam operator. They are not a private licensee like Northwestern or PPL Montana that is a publicly registered company in the stock exchange that is subject to disclosure transparency rules. They have no accountability. This is a total private enterprise that has a very small core at the top that makes lots of money that they don't even disseminate to their own tribal members. Racial discrimination here is not only against the non-tribal members, it's against their own members. Okay, these people live in squalor. I mean, I'm shocked to see what I see. Where's all the money going? I mean, what Swiss bank accounts are they using? Or do they send it to Hong Kong? I don't know. But the point is, no one's making them account. This federal government uses federal recognized tribal entity status to open up this giant black hole, and nothing in terms of information, nothing in terms of obligation under the law, nothing in terms of respect for constitutional rights is at all on their radar screen. They can do what they want without accountability. That doesn't fly. You've got a major dam here. You've got a national security issue because of the infinite wisdom of your U.S. congressional representatives, they enacted a law back 3 years ago that allows any Native American tribe to lease lands on their reservation for up to 75 years for a number of different purposes, including educational, religious, cultural, business, and agricultural. And the BIA doesn't have to go in and review each individual lease. Now, all they have to do is get a package of lease regulations that the tribe gives them, look at them, bless them, and the tribe can do whatever it wants, lease to lease. Okay? Now, again, that's part of our lawsuit. We have a rich factual record that we invite you to look at. It's on my firm's website, on the practices page, at the bottom. Okay, because we want to be open and transparent, and we try to invite the government to be open and transparent. But I got to tell you, even on FOIA, this government doesn't abide by the law. We went after the government a year ago on the endangerment findings for greenhouse gases. They had bad science. They had bad process for developing and reviewing science, and we wanted to challenge them in the court under a federal law known as the Information Quality Act. I've done extensive research and writing on this subject matter. We went and visited a number of state attorney generals, and because of the racial issue, they won't take this up. They can't challenge the White House. Or because they don't understand the science and development and review process, they won't take it up either. However, we do have commitment from one state AG, that of South Carolina, to write an amicus curiae, friend of the court brief, supporting a lawsuit that we would bring. Unrelated to this lawsuit, but yet very important because it's procedural law, again, at stake. They don't believe they have to put in a process to develop and review science that has credible peer review. Okay? What they do is they pick people from the universities to write sections of a report, and then they pick other people from the same universities to review that report. Or, and no doubt, these same people, the same universities get government grant monies from that agency. Either EPA, or the National Oceanic and Atmospheric Administration, NOAA, or Department of Interior. They play the game all the way around because if you don't have a financial direct conflict of interest, they say, well, the conflict of interest rules are not violated. However, what about institutional conflicts? Do you think a university is going to jeopardize its funding if it were to come out and identify a prospective peer reviewer that would go against the report? I don't think that would happen. But, so this government plays fast and loose with all the procedural rules that affect your rights, my rights, your children's rights, your grandchildren's rights. They've got to be stopped. Now, yeah, we have a deadline of January 20 or January 19, 2017. He's going to be gone, the president. But his infrastructure is still going to be there. He's had 8 years to create a new government beneath the current government. There's always a shadow government when one administration is in power from the opposite party. Okay, you have to believe that. And they've got people that they can work with to undermine the administration then in power. I remember this when I was advising, as an outside advisor, the Bush administration on European regulatory law. I came into contact with many Clinton leftovers, and they made it very miserable for the Bush administration to move forward. Now, I'm not defending the Bush administration because I actually went against it on the Law of the Sea Treaty because the Joint Chiefs of Staff didn't understand really what was in that treaty or didn't care enough because they wanted something from the rest of the world, and it was called Proliferation Security Initiative, PSI. They wanted everyone to tie into a government-to-government terrorist reporting mechanism, and they were willing to sell the Law of the Sea Treaty in order to get it. The problem was, the Law of the Sea Treaty is 1/3 environmental regulation. And when you ratify a treaty through the U.S. Senate, if the laws of the United States at that time do not equal, are not the same as the laws that would be required, or the rules that would be required in the treaty, you have to adjust. It's called implementing legislation. In order for the Senate to approve a treaty, they actually have to make a bill that implements what the rules of the treaty are, and if they have to change U.S. law in the process of implementing in that bill, then so be it. That's what we focused on, and then they couldn't say anything because it was true. You need facts in order to fight back. You need to be able to show the difference between what they say it is versus what it really is. That's what this lawsuit's going to be about. It's going to be about abrogation, exemption from all of the federal regulatory rules that this tribe is entitled to because of its federal recognized tribal entity status. It's that black rabbit hole in the Alice in Obamaland reality world that we live in now. Hopefully we can tear that rabbit hole to shreds, and maybe a clear sky rather than a dark sky will appear. Now, I always enjoy conferences like this because I can go, quote unquote, off the reservation a little bit on policy. And the point here is that there's a lot of policy informing what the law says. And that policy is taken from the Aboriginal indigenous peoples of the world. Okay, there is something in the UN entitled the Declaration of Rights of Indigenous Peoples. And this political declaration has of itself no legal force and effect. However, if a country that is a member of the United Nations wishes to take this document into its heart, so to speak, and reduce it to either executive orders, presidential memoranda, agency policy statements, it can. And as a result of all of that, embrace, you get federal laws or federal rules implemented by the federal agencies that bring it to your doorstep. Now, President Obama, I believe in 2010 or 2011, I'm not sure yet what year it was, unlike his predecessor, embraced that political declaration. In fact, he even provided a statement saying to the UN, here's how we're implementing it. And would you believe they're talking about the CSKT, they're talking about the Klamath River Basin, they're talking about all of the problem areas in the Pacific Northwest where you've got irrigators and businesses that are suffering at the hands of enviros and tribes. They want to give back the tribes their Aboriginal land and water, and they are explicit about it. They say it. They're rewriting the history. It wasn't the U.S. government that gave the tribes the right to exist on the reservation, but rather the tribes that gave the United States the ability to use the lands. That's the rewrite of history here. We found it in a 1967 memorandum from the Bureau of Indian Affairs. We found in a 1973 memorandum the setting up of a federal policy of benign racial discrimination. They said, any preferences given to a federally recognized tribal entity, either through a law specific to that purpose, or even the application of a facially neutral law in favor of the tribe, that is benign racial discrimination, and it doesn't require an in-depth review by a federal court to determine whether that is constitutional or unconstitutional. Amazing. Truly amazing. The government doesn't like that memorandum. It shows the basis for their policy. They don't like the 1967 memorandum, and when we bring that out, they're not going to like that because it shows the truth. But the fact is, if you were black, Hispanic, Jewish, Chinese, Buddhist, Hindu, and you were discriminated against, that law that was used to discriminate against you would be reviewed by a federal court according to a strict scrutiny review. That means that there has to be a balancing of interests between the government and the party victim affected. But when you are a federally recognized tribal entity, it is a benign racial discrimination, and you are only subject to a rational basis review. That means the government only needs to show some rational relationship between that bad law and some federal government policy, and it's upheld as constitutional. Only in an Alice in Obama-land reality can you find this. Clinton administration did the same thing. They used this as far as they could take it. This is political. Unfortunately, I learned the hard way in Washington that policy is driven by politics. Okay, there is no such thing as an abstract policy without a politics. So you see, if you really look at it from a macro level, a global level, the whole point of sustainable development is to do away with national boundaries. The whole way of the European Union to do away with national boundaries was a way to prevent future war, and they coalesce into one. They now want this at a global level. So, let's look at immigration policy as an example. We have federal immigration laws that don't enforce them because they offend international human rights principles, which transcend national border and trump, and I don't mean to say that politically, the U.S. Constitution. But hopefully he'll take up that issue, because it does affect his property rights. But nevertheless, the point is that when you take into account international law at the expense of national law, you lose your property rights, because remember, those property rights are negative. They're unique in the world. They're not positive rights as they are everywhere else. So when they rewrite their narrative and they bring in the international law and they focus on the international law, not the U.S. constitutional law, you get reserved water rights. You get contingent land rights. You get racially benign discrimination. That's what you get, and that's what they want you to have. Because then you have no rights. It's like you're tenants on your own land, and you don't own the land they do. And we all know that property owners have more rights than tenants do. And it's only because you have property that you have representation. Remember the old adage, no taxation without representation? No regulation without representation. But you have no representation without property rights. James Madison once said, and you can find this in the Federalist Papers, a person can be said to have not only a right in their property, but a property in their rights. We can't forget that. The government wants us to forget that. Hopefully through this lawsuit we can make a first dent in that armor and then take it forward from there. Thank you so much for listening to my presentation, and I'm now willing to take any questions you have. Yes?
Real quick, have you ever studied the 14th Amendment?
From time to time, yes.
There's been 500 million books written on the 14th Amendment, and I contend that all of our problems started, they absolved the Constitution, it absolved the 10th Amendment, and we've been living under the 14th Amendment ever since then.
Okay, what does the 10th Amendment mean to you?
That the states were sovereign. When our founding fathers came up with this country, they gave us sovereign states. We're the only country on the face of the earth that isn't controlled by a federal government. The 14th Amendment gave the federal government the power to take over the states.
Well, if you take it to its logical extreme, I would say, yeah, that does provide that opportunity. But think about what the 14th Amendment does. Okay, it prevents the states from denying you your federally guaranteed constitutional rights that are natural rights. States can be as corrupt or more corrupt than a federal government can be, as can locality. So that 14th Amendment does serve a good purpose. Anything can be distorted. Okay, they've taken the Constitution and shredded it and applied it in ways that the founders never intended it to be applied. They warned about how it could be applied.
You know, under Article 3 of the Constitution, the Supreme Court had very little power. The 14th Amendment gave it all kinds of power.
Again, anybody can usurp power. Okay, it takes the wisdom and the discipline of those in governance not to usurp the power. Again, we have a republic if we can keep it. That includes all the officers of government. legislative branch, executive branch, judicial branch. But in New York versus United States in 2000, Sandra Day O'Connor presided. The 10th Amendment is not for the sake of the states. The 10th Amendment is to protect individual constitutional rights, both from the state and the federal government. Okay? That's what the 10th Amendment's really about. Yes?
Does a sovereign government that has a recreational water right on a body of water, does it have the right to sell fishing licenses on that body of water?
A sovereign government on a body of water have rights to sell fishing licenses.
If they have the recreational water rights on that water?
Larry, why don't
I'm going to defer.
Yeah, why don't you leave that one to me when I get up?
Yes.
I'll answer your question. I'll answer your question when I get up there. The next part is about how the government owns water, and we'll get there.
Okay.
Mr. Fenn.
Last winter, Larry, you and I had a running conversation about the process of the Sailor's Kootenai Water Compact.
Can you speak up, Bob?
Last winter,
Yeah.
you and I had a running conversation about the process of the Sailor's Kootenai Water Compact and how it was being presented to our legislature. My question is based on the compact itself. Attorney General Fox said he ruled on the constitutionality of the compact, the contract. That's 500 pages. There's another 1,000 pages below it that we call the abstracts. And I'm wondering if, since we were duped as a society, since the people of Montana were defrauded with this contract, this compact, is it enough ammo to say that the Attorney General did not issue a written legal opinion as to the constitutionality of the abstracts, because the abstracts, as you educated me, override the compact itself. So since they override, and there is no written legal opinion from the Attorney General's office, is that a strong enough argument to call for a special session of the Montana legislature to repeal this compact?
Okay, that is a very long question.
Big question.
I'm Irish.
Bless you for that. First of all, I can't opine as to the legality of Attorney General Fox's opinion because I haven't even seen the opinion. So I don't know whether it exists or not, so I have to withhold comment until I see it. If he would be so magnanimous in showing us where it might be. But two, yes, there are many technical abstracts that identify the water rights of the various parties to the compact. And those technical abstracts, in the event they were to conflict with the terms of the compact itself, would govern. That is a problem when the legislature never even had the opportunity to review those abstracts. So just on that count alone, one could raise the question of whether there should be a special session. But really, the emphasis of our call to the legislature to initiate a special session is because of all of the 30 or so amendments made to the Kerr Dam license in the 1990s, during the Clinton administration, behind closed doors, without providing any of you public hearing rights. And that in itself provides the legislature with the grounds to say they were not properly informed about how the dam relates to the compact and all the information that they used to base their decision to enact SB 262. How could the legislature have maintained an informed decision-making process without the information?
That's right.
Thank you very much. Can I answer those two questions?
Sure, go ahead.
Okay. David.
Just a quick question. When you mentioned the tribes, Confederated Salish and Kootenai tribes, can you also refer to them, when you say tribes, does that also mean the CSKT Corporation?
Well, that's a good question, because the CSKT Corporation is a federally chartered corporation off the Indian Reorganization Act, Chapter 17. Okay, it has limited sovereignty, limited sovereign immunity. You could sue that company if it does something that they're not supposed to do. So they're a target. they're a potential target. But you gotta look at their corporate structure. They got lots of companies in there. They get lots of government contracts. They do lots of things that we've exposed on our website, in the annual reports and in the newsletters that you all might want to read. And that was the reason why we brought up the Turkey and we brought up the national security issue, because we found things in their annual reports and newsletters that raised people's eyebrows. What are they doing? Who are they doing it with? And how might what they're doing with whom they do it with affect you all? Okay? Taking into account also the congressional legislation that we found on reservation leasing, taking into account what's happening in the outside world, because you got to look, even though you're local, you got to look global. Okay, this is one of these interactive times in history where you can't shut your eyes down because you're used to doing things a certain way. I mean, there are good things about the internet, and there certainly are bad things about the internet. But if you figure out how to harness the information on there and you're able to vet it, boy, you're really much more informed than the people of the past. And the fact that you can communicate with each other as you can, that is wonderful. Because you can organize, you can shut down your representatives, and you can tell them, finally, that they work for you. Thank you very much.